Hello, and welcome to Incapacity Planning, Why It's Necessary for You. As the subtitle says, before decision making and judgment are impaired. My name is Andrew Gilliland. I am an attorney. I also have a master's in taxation from the University of Florida. Go Gators. As always with these webinars, we have several goals, but the primary goal that we look forward to is helping you understand how you can plan for you and your loved ones to make sure there's a smooth transition. In this case, should you become impaired and not able to make your decisions. I do love what I do. I have the opportunity to work with you to make sure that everything you've worked for and everything that you will work for goes as you want it to go. As mentioned before, I did attend the University of Florida. Go Gators. We're required to say that when we get our degree to get a master's in taxation so I can understand the framework for the assets that you could have in your estate plan. My goal, as always, is to understand your estate planning goals and to put incapacity planning within that. In every estate plan, you really kind of plan out for three major sort of things. You plan as if you could die tomorrow. You plan as if you could die in 50 years from now. And in the interim, you plan for what we call the end of life decisions or incapacity, should you become impaired. So we always look for that opportunity to be an advisor and a counselor to make sure that we can meet all three of these areas in every estate plan. I do look forward to meeting and working with you. All right, so the outline today is we're going to talk a little bit about the prevalence of incapacity. Most people are aware of this. Most of us have had a loved one who's become incapacitated, or we know of somebody who has become incapacitated. But we'll throw some statistics out there that will show that this is a problem that is increasing, partly because we have a very aging population, and we'll see that. We'll also talk about the incapacity framework. There's essentially three different avenues you could do for incapacity, and we'll go through each one of those and show which ones are better and which ones would more than likely meet your needs. We'll talk about your specific goals in a general sense, right? Everyone has some sort of categories as to their goals for incapacity planning. And then we'll discuss pre-planning versus crisis planning, okay? All right, so then there'll be a summary and some questions at. All right, so does incapacity have a prevalence? Is that something that occurs in society? And the answer is yes, it is. The leading causes of death in the U.S., this is a stat from about 2015, 2016 that I updated and looked at, and it hasn't changed. So originally when I had this, it was from 5 years ago. Now we look at today, and this really does not change. As you will note here, though, is that most of these, right, with the exception of number 3, accidents, right, unintentional injuries, these are conditions, and I guess maybe number 10, self-harm, suicide, right? These are conditions, though, that ultimately will last for a long period of time. And at the end stages of them, it can be very debilitating. And you may not have the opportunity, or your loved one may not have the opportunity to be able to make decisions for themselves. All right, so the prevalence, as you can tell, this is just a stat we put out there to show that, hey, Alzheimer's disease, now it affects 1 in 9 people age 65 and older. And if you look at the pie chart there, right, you can see that, under 65 years, 4%. So for the most part, which is great, and again, these stats come from 2014, is that, hey, the younger you are, the more likely you are to be able to make those decisions. But then look how much it jumps in the next decade after 65, right? Boom. Jumps up to 15%. Then look how much it jumps in the next decade after that, jumps up to 44%. And then when you get to 85, it comes down just slightly. But as you can see, Alzheimer's clearly affects a lot of individuals and a lot of families. And it has sort of its sidekick, which is dementia, right? Dementia where they're sort of there, they have periods of fluidity, but just the decision making is just kind of getting a little off the rail there, right? All right, so Alzheimer's disease, the number will grow rapidly each year as the size and proportion of the population 65 and older increases. We just saw that, right? More women than men have it. Almost 2/3 are women. And the question is why? Well, women still live longer. But no, there's no evidence to suggest that women are more likely to develop it. So the prevalence data in the U.S. is that stroke is the leading cause of serious long-term disability. 34% of people hospitalized for stroke were younger than 65 years of age. Okay, so remember that we have that Alzheimer's sort of dementia curve at 65, right? Where before that, it was about 4%. Above that, it was just increasing exponentially. Here, we're looking at under 65, it's a stroke. And that's 34% of the people. And there's some other stats there, and you can look at the common risk factor, and this isn't like a scare you, but it is a, hey, we do need to take care of ourselves. So 49% of all Americans have at least one risk factor, such as high blood pressure, high cholesterol, smoking. And so you just have, the stroke is out there. And that's something that if you don't plan for it, right, it's not one of those debilitating in the sense that, hey, you can see it coming down the road. Sometimes it happens right away, and you're in a position to where you have to deal with it instantly. All right, so what is the framework? So now I've kind of thrown the scary stuff out there, right, and said, hey, we're all going to end up somewhere unless we have, an accident that kills us or, something catastrophic of that nature. For the most part, we all sort of end up in this, going down this road. And again, we've all had loved ones who have been there. So if you look at the framework for incapacity planning, it's, really there's sort of these three areas. You have a power of attorney. Many have heard of that. Its sidekick is the medical directive, okay? And we'll talk about that in a minute. Then you have the revocable living trust, okay? Many have heard of the term living trust, and revocable living trust is the same thing. And then you have the guardian conservatorship, okay? And if you look at the bottom of this slide, you see that, hey, when you're well, you can do your pre-planning, before the incapacitating event. After the incapacitating event, you end up in crisis planning. And then obviously the end of that is you're either restored to capacity, which does happen. So if you have a stroke at age 53, right, and the initial, and I've seen this, I had a friend that this literally happened to. He's a nurse, and at 53-ish, he had a stroke. And, there was a period of several years where he was not there, and then ultimately he did regain his capacity. So it doesn't necessarily have to be forever and ever, but it could be. Okay, so again, pre-planning versus crisis planning. All right, so let's talk about a power of attorney. It's a very familiar term for a lot of people. A power of attorney creates this relationship. We call it an agent relationship. Okay, you have a principal, which would be you, if you're the person creating the power of attorney. And then you have an agent, which we call the servant, which is the person who acts on your behalf. Okay, a power of attorney has certain formalities that need to happen. Okay, in California, we have a statutory form of power of attorney. What we have done is we have put, you take that statutory form, and then we have added all the specific powers that the individuals could have, and we explain them a little bit. So it's a lot more full than just, pulling off the form off the internet. The interesting thing about a power of attorney is that it is just semi-private, meaning people can actually see it, right? Because how do you use a power of attorney? A typical scenario for a power of attorney would be, hey, mom's home alone, living in the house she's lived in. She has now had a stroke. I have a power of attorney. I need to sell that residence because she had to go into a facility, or she had to come live with me. So how do I do that? Under a power of attorney, you would then take it to the real estate agent and say, look, I can sign an agreement with you on behalf of my mother. Okay, and then at the closing, so you do that, right? And then let's say everything goes well, the house gets ready, so you can sign on behalf of your mother in this case as their agent. Okay, so you can sign their name by so-and-so as the agent under that power of attorney dated such and such. So it is semi-private in the sense that no one knows about it until you have to use it. Okay, so that's what a power of attorney is. Power of attorneys do terminate upon death. Okay, now the sort of risky part about a power of attorney, it's not super risky, but it can be, is once it's out there, so if I give my power of attorney to somebody else and they have a copy of it, they can wave it around and go do whatever they want until it's revoked. And the only way to revoke it is to send that individual a notice of revocation, but that doesn't mean they still don't have the power of attorney in their hands, and they can't go out and cause problems using it. So it can be slightly problematic in that sense. So that's, it's semi-private. It is a tool to use, and it is a good tool. Okay, but it can also just, have this other side to it, so you have to be careful with it. So powers of attorney, so let's talk about it. I put it all kind of right here. They do help manage incapacity. They are a one-way street. Okay, they do not remove rights from the principal, meaning you, the person who signed it. You still have your rights. So if you still have capacity, they can't overrule you, right? So if the two of you are sitting there and they have a power of attorney that you've authorized them as your agent and you're still there and able to make decisions. You could sit down at a table with someone across and your agent couldn't say, well, ignore them, I have power of attorney. No, that's not the way it works. As I mentioned, the statutory form often can contain inadequate instructions. It's critical. And this would be sort of my pitch for don't use a form. Forms don't work. You need a lawyer to walk you through it to make sure that it says what you want it to say. Some third parties may be reluctant to honor it. Banks are notorious for this. Third parties do see the contents of the power of attorney. That's the POAs, okay? Sometimes you have no backup agent, so you just appointed one person. Maybe that person is out of the picture now. And, so there's a couple other things that go on with powers of attorneys there. All right, so let's talk about medical directives. Medical directives are akin to a power of attorney, but it deals more with medical decisions, like it says in that first line there. It lets another act on your behalf for medical decisions as your agent. Again, it doesn't remove rights from you as the principal. The agent cannot overrule you, right? And then again, the instructions have to be clear. Third parties may be reluctant to honor, but not so much like with the power of attorney where there's maybe a concern as to its validity or not. So, medical directive goes hand in hand with the power of attorney, and this just deals specifically with medical decisions. And another sort of, and I guess I could have added another slide, but it's that living will that a lot of people have heard of. Your medical directive does contain language dealing with your choice whether to prolong life or not to prolong life, whether or not you want to donate organs and tissues. Living will is one that deals solely with your choice whether to prolong or not prolong life. So that's what a medical directive has. All right, so a revocable living trust. This is sort of the catch-all wonderful document that most of us attorneys would say this is sort of the best way to do it for several reasons. First of all, let's just sort of tell you what a revocable living trust is. A revocable living trust is a contract with yourself. Okay, so you would be the grantor, the person putting property into it, as well as the trustee, the person making the decision. It's private transfer authority. Unlike a power of attorney, the revocable living trust isn't bandied about and handed out. There's a specific document. If someone needs to know the validity of a trust, it's called the certificate of trust, and it provides very limited information, so they don't get to read your whole trust. So you would be what we'd call the initial trustee or the boss. The successor trustee would be the person who makes the decisions for you should you become incapacitated, or the person who makes the decisions for the trust when you're no longer, when you pass on. So that's the benefit of a revocable living trust. It's very private. It governs all assets that are put into it. That's why we kind of, we prefer a revocable living trust, because it handles the power of attorney and the medical directive all placed in one. In your typical estate plan, you'll still have a power of attorney and a medical directive, but we call that sort of the belt and suspenders approach, meaning if the property is in the revocable living trust, the revocable living trust would govern it. If the property is not, then the power of attorney and the medical directive with it. All right, so revocable living trust, here's some of the aspects of it. The trust maker, you name who will be the successor, so you control that. I want so-and-so to do it. If there's two spouses there, it always kicks over by default, or at least it typically does, to the spouse, right? And then when there's only one of you there, then it kicks over to whoever you want. It could be a child, could be whomever you choose to decide. The trust maker specifies how incapacity or disability is determined. That's the trigger. So, my typical revocable living trust will say it's on when two physicians have determined the individual is incapacitated. Okay, some will say just one, and that's the trigger. So until that has happened, you cannot, the successor trustee cannot make those decisions. Third parties do accept authority as successor trustees because there is a California statute that says, hey, you have to do this. And in fact, our certificate of trust that I spoke of before has that very specific language and reference to that California trust. It does remain private. If assets are funded to the trust, you can avoid a conservatorship, which is the third aspect of it. So this is what we call the crisis planning, that incapacitating event has already happened. There's no plan in place, and someone needs to make decisions on you or a loved one's behalf. What you have to do there is go to court. You file a petition. The court then will, there'll be some research going on. The court will appoint an attorney for what we call the conservatee, the person who is incapacitated, and then a court investigator will come out, which is an individual to determine what the scenario and whether the person asking to be the conservator is able to do so. Right? We have to go to the doctor and get an incapacity declaration. So it's very much a public, non-private. Lots of hands are in, and there's also sort of all these accounting and other aspects that have to happen with respect to what is actually owned by you or your loved one at the time. The judge ultimately names a guardian or conservator. Okay, so it's out of your control when you go down this road. It's whoever filed the petition. If there's no objections to it, that's how it works. So here we go. Guardianship, conservatorship. Person loses control. Judge decides. Family may lose control. The judge can come in and say, the children can't do this. Maybe there's some criminal history or some drug history. So now we're going to appoint what we call a public guardian ad litem to handle the conservatorship. These are hearings. They are public. You show up at a hearing. Rights are removed. So in a conservatorship, the individual loses their rights. Formal inventories, as I was saying, accounting is required until death or capacity is restored. The court may require a bond, and this is important because that's another expense out of the pocket. And usually they do, unless it's waived by everybody. The process can be expensive and burdensome. And any interested party may petition for a court action. There's no real protection there. All right, so your goals for incapacity planning are simple, right? You want to relieve your concerns about not being able to make decisions. You want to put a plan in place that you design, right? That pre-planning, not crisis planning. And you want to appoint someone you trust to make those decisions for you. And not only that, you want to appoint a backup should that person themselves not be able to do it. So those are ultimately the goals of doing it. Common planning motivators, why people tend to want to do this, is they've been diagnosed with a life-threatening illness, right? A recent accident. They have minor children that want to make sure they're taken care of. Or, there's that trigger. Someone has died. You've moved to a new state. Every state is state-specific. So if you come to California from, let's say, Utah, you're going to be differently. If you go from California to Utah, you're going to want to update your forms. Or some sort of change in financial condition. Okay? Those are your common planning motives as to why. And as we've already discussed a bit, there's pre-planning, crisis planning. Pre-planning allows for continued decision-making without unnecessary interruption if incapacity occurs. And I want to be clear. It could take 45 to 60 days to get a hearing if you're doing the crisis planning. Trusted successor decision-makings are pre-selected. It's just very smooth. Custom provisions and legal instruments can be put in place. If you're using a living trust and the assets are already funded to the trust, the successor trustee can manage it right away. There's no delay going on there. Crisis planning is never optimal and may place the newly incapacitated person, their state and family in a tenuous position. And let me just give an example of this. I've had multiple cases where they eventually want to do a conservatorship because the home is about ready to be foreclosed upon. The individual has not been paying bills. Not that they couldn't, but their mental incapacity has caused the delay. Okay? And so they're saying, we need to make sure that this doesn't happen, because let's say there's even equity in the residence, or even that they just want to stay in it. But again, without authority, they can't get at the bank account. The money's there, but they can't get at it to pay off the back owed mortgage payments. Then you end up in court. And now we're at a 45 to 60 day delay. Sometimes, you can speed it up, but again, that's costly. So it's just really kind of problematic in many ways. And when you get into this crisis planning, and I like the last sort of bullet point there, increased potential for disputes. Yeah, lots of fighting can go on at this time. Lots of fighting amongst siblings. So pre-planning for loss of control, a well-drafted POA is great, right? Pre-selection, trusted individuals. You can do home care clauses, whistleblowing permission, which is someone's, insider dealing. You can put in how you're going to remove the agent. You can nominate them. They're all great tools. Using a living trust, okay? Funding the trust with assets before incapacity. Some people will get a living trust, they'll download it off the internet, right? But never fund it properly. And that defeats the purpose of the living trust because the trust only governs what's in its name. You can define incapacity determination. You can determine how a successor trustee is removed. You can address short support distributions, how you want them to go. You can do all sorts of things within a trust. It's very, very flexible. Guardianship, conservatorship. Removal of rights may be necessary. Is this a crisis plan? It is. Pre-planning for incapacity serves to avoid court intervention whenever possible. And again, it's not like a conservatorship is the worst thing in the world. It's just not the best thing in the world. I mean, a conservatorship can be a very necessary tool and be very helpful to protect your loved one. But it's just a question of if you can do it now while you have capacity, just do it. All right, so before I get to a few questions, here's my contact information. You can see my phone number and my email there, as well as my website. Consultations are free, so you can do it. I would just say that it is better to do it now while you have the capacity to set it up perfectly, knowing that based on the statistics we went through, at some point in our lives, we do end up in a position where we may need somebody else to make decisions for us. So contact us for a free 30-minute consultation. Thank you for attending. And again, I'm going to go to the next slide. We'll have some questions, and we'll go from there.